Imagine this. Your neighbor's leak floods your condo, causing an absolute disaster. It is a total nightmare scenario. And it can happen to just about anyone living in an HOA. But the real mystery here, it isn't where the water came from. It's who was legally on the hook to pay for it all. So let's dive in. I mean, it's the kind of question that can genuinely keep you up at night. You walk in the door and bam, soaked ceilings, damaged walls, all your stuff is ruined. Your upstairs neighbor says they're sorry, but who's actually on the hook financially for the chaos they caused? Well, as this case is going to show us, the answer is not always as simple as you think. All right, let's get into the nitty-gritty of our case here. And this isn't just some hypothetical, This was a real-deal legal dispute that made its way through a formal hearing, and it all kicks off with one very flooded condo. Okay, so here are our key players. We've got the petitioner, Bonnie Senftner. She's the owner of Unit 116, the one with all the water damage. And on the other side, we have the respondent, the Desert Wind Condominium Association. That's the HOA. And the incident? A pretty major water leak that started in the unit right above her, Unit 216. Now, you'd probably assume that Miss Senftner would go straight after the owner of Unit 216, right? I mean, that makes sense. But that's not what she did. No, she aimed her legal battle at a much, much bigger target. And this is the critical point, the central dispute. Miss Senftner didn't sue her neighbor. She sued the homeowners association. Her argument was that the association itself had violated the community's own rules, the CC&Rs, and because of that, they were responsible for her damages. The association, of course, fired right back, basically saying, whoa, not our problem, this is between you and the other owner. Now, check this out, because this right here was the petitioner's smoking gun. She built her entire case around this one sentence from the CC&Rs, Section 14.2. She was convinced this language proved the HOA had to step in and handle everything. I mean, it seems pretty clear, doesn't it? An owner causes damage, that owner has to fix it. Let's see how that logic held up. Okay, so before we get back to the legal back and forth, let's play detective for a minute. We need to figure out what actually caused this flood. So the association sent in the plumbers to trace the source. The investigation was super methodical. First things first, the plumber checked the building's common pipes, the main plumbing. Nope, no leaks there. Then they quickly located the source. It was a washing machine, but not just any washing machine, one inside Unit 216. And the final confirmation? It was installed all wrong, causing its discharge hose to overflow the sink drain it was hooked into. That overflow is what started this whole mess. And here is where the plot really thickens. Because even though the association was claiming they weren't responsible, they did step in and pay for some pretty big repairs. They fixed the busted pipe, they brought in a mold remediation crew, and they even put up new drywall. Now, if you're the owner, this has to look like a total admission of guilt, right? I mean, this is the key question that adds so much drama to the case. If you pay to fix a problem, doesn't that pretty much mean you're taking responsibility for it? Well, legally speaking, it's a little more complicated than that. And that brings us to the absolute turning point of this whole thing. Seriously, everything hinged on that key piece of evidence, Section 14.2, and more specifically, the definition of just two little words. So remember that quote she was banking on? If any party wall is damaged? Well, Ms. Senftner's entire legal argument, every bit of it, depended on the damage being to a party wall. So the judge had to ask a very simple but incredibly critical question. What exactly is a party wall, according to the document itself? And boom, this is why you always read the fine print. Buried in a completely different part of the CC&Rs, Section 1.12 was the answer. A party wall isn't just any old wall. It's a very specific structural wall that's right on the dividing line between two units, one that's used by both owners. And with that one definition, her whole case just fell apart. The water didn't come from a shared structural wall between the two condos. It came from a messed up washing machine hookup inside Unit 216. So that whole party wall rule, it just didn't apply. Not at all. So, with that central argument completely dismantled, there was really only one thing left to do. It was time for the administrative law judge to make a final ruling based on all the evidence that was presented. Now, before we get to the verdict, it's important to understand the standard of proof here.
This isn't like a criminal trial where you need proof beyond a reasonable doubt. No, here the petitioner just had to show that it was more likely than not that her side of the story was the right one. The evidence just had to tip the scales in her favor, even just a tiny bit.
But in the end, she couldn't meet that burden. The judge dismissed her entire petition against the association. It was over. So let's break down the judge's reasoning point by point. First, as we saw, that party wall argument just didn't hold water. Second, the evidence was crystal clear that the leak came from the washing machine in Unit 216. Third, the rule she tried to use actually puts the responsibility on the owner who caused the mess, not the HOA. And finally, the judge said that just because the association chose to pay for some repairs, that didn't legally mean they had to pay for everything else. It was a choice, not a legal obligation. So, after all that, what is the big takeaway from this whole legal mess? Well, it's a huge lesson for every single person who lives in a community with shared rules. I mean, just think about it for a second. The entire dispute, the lawyers, the stress, the formal hearing, all of it came down to the specific wording in just 2 short sections of a legal document. It all boiled down to the definition of a party wall and a rule about who pays when a neighbor causes damage. And that's really the ultimate lesson here. You know, those thick booklets of rules, the CC&Rs that you get when you move in, they aren't just suggestions. They are a legally binding contract between you and everyone else in your community. That fine print really, really matters. And as we just saw, it can absolutely make or break a legal case. Which, leaves us with one final thought. You probably know the rules about where to put your trash cans or how often to mow your lawn. But when a real disaster hits, do you truly know what your rights and responsibilities are? Might be worth taking a look.